Yes,
Angela
ma'am, that's
Manning
me.
on behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be.
Before we even step into this courtroom, let's set the stage. Because what you're about to witness isn't just a routine arraignment. This is one of those rare cases where confidence meets complete misunderstanding of the legal system and refuses to back down. Today's defendant walks in believing she knows the law better than the judge, the prosecutor, and frankly, the entire system combined. She claims retaliation, constitutional violations, and even threatens to sue the court itself, all before the case has barely begun. Now here's where things get even more intense. Her argument isn't just about legal technicalities. She's tying everything to a deeply emotional claim involving her child, accusations against law enforcement, and a narrative that paints her as the only person telling the truth in a system she believes is corrupt. But the big question is, does she actually understand what's happening in court? Or is this a textbook example of someone completely out of their depth? Pay close attention because as this unfolds, you'll see moments of contradiction, escalating tension, and a judge who's trying.
Ms. Manarino this morning.
Yes. I
Ms.
think all
Manarino,
charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights. Michigan.
Personal. You do not need to post any money. What you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In an interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which is what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will.
This is the first major red flag. Declining a court-appointed attorney is a serious decision, especially at the very beginning of a criminal case. Most defendants rely heavily on legal counsel because even basic procedural missteps can have long-term consequences. But instead, she doubles down on self-representation, citing that she's studying to be a lawyer. Now, that might sound confident on the surface, but in a courtroom, confidence without actual legal training can be dangerous. This moment sets the tone for everything that follows. The judge now has to balance two responsibilities: respecting her right to represent herself, while also ensuring she understands the seriousness of what she's doing. And as we're about to see, that balance becomes increasingly difficult because she doesn't just misunderstand the process.
It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls.
Instead of focusing on the purpose of the arraignment, which is simply to enter a plea, she immediately jumps into arguing for dismissal. Now, technically, yes, you can request dismissal at different stages of a case, but timing and procedure matter, and right now, she's trying to argue substance before the court has even moved past the basics. What's also important is her reasoning. She claims retaliation for seeking help regarding a child. That's a serious allegation. But in court, claims alone aren't enough. You need evidence, proper filings, and the correct procedural timing. Without those, even legitimate concerns can come across as disorganized.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the
Yes,
first
but
appearance where
I
you
could ask for
respond-
it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for...
The prosecutor is clearly explaining the procedural path, either a plea or moving forward to trial, while the defendant keeps circling back to dismissal. This is a classic example of two people operating on completely different wavelengths in a courtroom. From the court's perspective, there's a structured sequence: arraignment, pretrial, discovery, motions, and then potentially trial. But she's trying to skip steps entirely. And while she repeatedly references constitutional rights, she doesn't seem to anchor those claims in specific legal standards or filings. This creates a frustrating dynamic, because even if she believes she's right, the court cannot act on generalized claims without proper legal framing. And the longer this continues, the more it risks...
Things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her.
The emotional core of her argument, and this is where things get complicated. She's alleging that a child is in danger, that law enforcement ignored her, and that the situation escalated into charges against her instead. If true, that's deeply concerning. But again, the courtroom requires structure. The emotional urgency doesn't replace evidentiary standards. What's happening here is a collision between personal crisis and legal process. She's speaking from a place of urgency and frustration, but the court is bound by procedure and documentation. And when those two don't align, it often feels, especially to the person involved.
Actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her. And I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind.
Suing the court, alleging malicious prosecution, citing constitutional violations, these are serious claims. But in this context, they're being used more as a defensive reaction than a structured legal strategy. Courts hear threats of lawsuits more often than people think, especially from self-represented individuals. The difference between a credible legal claim and an empty threat comes down to execution, filings, evidence, jurisdiction, and legal standards. Without those, statements like this don't carry weight. They actually risk damaging how the court perceives you. At this point, the judge isn't reacting emotionally. Instead, they're staying focused on procedure. And that contrast between escalating accusations and calm judicial process is what defines this.
Police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren Police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you've made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So
that's what I'm asking for the agreement.
Communication breakdown. The judge is trying to simplify the question, just a yes or no about contact, while she continues to expand into broader arguments about custody, safety, and past events. And this is critical. In court, answering the question being asked is everything. When a defendant consistently avoids direct answers and redirects into unrelated issues, it not only frustrates the process but also weakens their position. Judges rely on clarity to make decisions, especially regarding bond conditions. From the outside, it may feel like she's not being heard, but from the court's perspective, she's not engaging with the specific legal questions in front of her. And that disconnect continues to widen as the hearing progresses.
Biological children from me, and the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren Police to have these charges brought against me, and he perjured himself. The Van Buren Police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they use to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am,
and I would like to know why I would not be allowed to talk to Charles about my daughter, Haley.